Thank you, Mr. Chair.
Thank you. I do want to acknowledge other members have come and gone with other committees meeting this morning, so not sure whether or not Senator Tillis, Senator Booker, Senator Klobuchar, or others will return. But in the meantime, we do have additional questions. We'll start with the second round here. Now, over the years, attorneys general from both parties have used a procedure called self-certification to influence and change immigration law. The Trump administration used self-certification a record 17 times, including to restrict asylum eligibility and strip immigration judges of authority to decide when to put an end or to pause a case. In fact, former Attorney General Barr even used self-certification to reopen a 14-year-old asylum case and, as if that wasn't concerning enough, self-referred and immediately reviewed a case relevant to oral arguments taking place before the Supreme Court just 5 days later. After the Biden administration took office, Attorney General Garland has used self-certification to vacate or reverse decisions that did not fit with its policy objectives. Question for Judge Sankoff. Can you discuss how self-certification cases can affect non-citizens trying to navigate the process, and also how self-certification impacts your work as a judge?
Thank you for that question. So, as we know, immigration judges decide their cases based on precedent decisions. And the precedent that we follow is issued by the Board of Immigration Appeals, any Attorney General decisions, and the federal courts. So when a new Attorney General comes into office, they have the authority to certify cases to themselves and essentially rewrite the presiding law that we then all apply. One Attorney General might interpret a clause expansively, another restrictively. So the IJs are then bound by that new precedent. Now this creates uncertainty throughout all of the parties, throughout the entire system and all of the parties that are appearing before us. It also creates incentives to appeal unfavorable rulings, because an unfavorable ruling today based on the law as it stands today might be more favorable a few years down the road when a new Attorney General is appointed. This results in remands, which burdens the court and expands the backlog.
Thank you. I also want to bring in Ms. Gambler here for a minute on issues of management and the backlog. Now, thanks in large part to persistent under-resourcing as compared to other immigration enforcement agencies, the courts have long struggled to keep up with the number of cases referred to them by DHS. The court backlog has grown consistently since 2007, as you've laid out. It doubled under the previous administration and further increased during the COVID-19 pandemic, while many courts were physically closed. Despite a record couple of years of case completions under the current administration, the court backlog is now well over 2 million cases and growing. I want to afford you an opportunity to share what steps could EOIR take to help address the backlog.
Thank you, Chair. We think it's critically important for EOIR to address the recommendations that GAO has made to it over the years. Those recommendations are really designed to help improve the management and thus help EOIR improve the efficiency of court operations. And there's a particular recommendation that I would like to highlight that is longstanding, and that is the need for EOIR to develop a strategic workforce plan. That is important because that type of workforce planning efforts helps an agency identify what gaps and skills they need to have in their workforce, how they're going to fill any skill and competency gaps they have, and then monitor progress in doing that. A strategic workforce plan also helps an agency be positioned then to speak with Congress about what the resource needs are and how the agency will go about meeting those resource needs. So this is a long-standing recommendation that GAO has made to EOIR. We made it back in 2017. It's actually a priority recommendation, and we think it's critically important that EOIR take action to address that and work on getting a strategic workforce plan in place.
Okay, and in the spirit of trying to address the backlog, I keep coming back to the recommendations Mr. Simpson has offered, the reference to whether it's 30 to 70, the 20 to 80, the ratio of successful versus unsuccessful claims. It change over time. It changes region to region across the country. But to suggest that, well, it's just simply a clogged system. You know, if you can quickly, easily just remove cases without merit and be able to focus the system on those that have more merit. Question actually from a SANCOM, you're an actual judge, you deal with this. Are unsuccessful cases all meritless, frivolous? Are there maybe a percentage that are sort of close calls and tougher to distinguish? How could you, with the magic wand, just get rid of 70, 80%? Or is there a true due process here that we need to keep in mind?
Senator Padilla, you raise such a good point, and the way you've articulated, I think, is very, very helpful. As the judge, you have to look at all of the evidence that's been provided. Now, for example, a case may end up being denied because a respondent filed their application for relief a year and 1 day later than the application was required to be filed. You know, you must file within 1 year of arrival. But they want to make a valid argument as to why they missed that deadline. You, as the judge, might in the end decide it's not valid, but they have the right to make that, to present that argument. And those are, you know, they're sincere arguments that have to be addressed. That is the way that we run our system.
Thank you.
Thank you.
Senator Cornyn.